5 seconds to go. Start. In paragraph 22 of the written statement filed by defendant numbers 1 to 5 in suit 1, it was specifically stated that namaz had been offered until 16 December 1949. Stop. Similarly, in paragraph 26 of the written statement filed on behalf of defendant numbers 6 to 8 in suit 3, it was also stated that namaz had been continuously offered till 16 December 1949. Stop. Thus, for the purpose of the issue of limitation, it is necessary to proceed on the basis that the last namaz was offered on 16 December 1949. Stop. Para. Before the High Court, it was urged by learned counsel appearing on behalf of defendant number 20 that, para. In a suit for declaration, Article 120 of the Limitation Act 1908 is applicable, and even if the cause of action as set out in paragraph 23 is taken as correct, the suit, which was instituted after the expiry of 6 years, is barred by limitation, and para. Even if Article 120 is held to be inapplicable and Articles 142 and 144 are held to apply, the cause of action arose on 16 December 1949 and was not a continuing wrong. Stop. Hence, the suit, which was filed on 18 December 1961 after the expiry of 12 years, is barred by limitation, albeit by 2 days. Stop. Para. Dealing with the provisions of section 145, Justice Sudhir Agarwal held that the proceeding is not of a judicial nature, nor does the magistrate deal with it as if it were a suit for immovable property. Stop. The proceedings under section 145 would neither result in extension of limitation, nor is any exclusion provided for the purpose of computing limitation. Stop. The appointment of a receiver by the magistrate merely made the property custodial legis and is not a dispossession within the meaning of Article 142 of the Limitation Act. Stop. The attachment of the property does not either amount to the dispossession of the owner or a discontinuance of possession. Stop. Adverting to the decision of this court in Deokar versus Shio Prasad Singh, the High Court noted the principle that following an order of attachment under section 145, the property is custodial legis, since it is not in the possession of any private individual, there is no need to seek a relief for the restoration of possession, and a declaration of title would be sufficient. Stop. Relief of possession is not required because no private defendant would be in a position to deliver possession to the plaintiff, and the magistrate holds possession during the period of attachment for the party who is ultimately found entitled to it upon adjudication. Stop. Para. Having set out the position in law, Justice Sudhir Agarwal held that the plaintiff in suit 4 has no averment that the plaintiffs were dispossessed of the property which they had already possessed. Stop. On the contrary, the plea was that by the placement of idols inside the mosque, there was an act of desecration which interfered with the right of the plaintiffs to worship. Stop.